A super PAC has no ability to shield the identity of its donors. In fact, disclosure is part of the reason that there is a super PAC. And yet we often see, here we go, individuals or corporations, some anonymous entity, making a donation to what appears to be a completely shell corporation designed just for the purpose of laundering money into a super PAC and violating the law that would require disclosure of the true identity, which would seem to be a pretty clear 441F violation, making a contribution in the name of another. And I'm wondering why it is that the Justice Department doesn't appear to bring any of those cases. And I think the immediate answer to that question, you can correct me if I'm wrong, but I think the immediate answer to that question is that it's because you defer to the IRS to bring those cases to the department because they come out of the tax world. And I don't know why, particularly the false statements, let me focus on that because that comes off the IRS report. I can see why the Department of Justice would want to defer to the IRS on criminal prosecutions involving complex tax matters. Making a false statement is something the department prosecutes all the time. It doesn't take particular tax expertise to recognize a false statement when you see one or to prosecute one when you see one. What are the inhibiting factors that prevent DOJ from going forward? Are you rethinking deferring so much to the IRS in these matters where it's not a tax-specific underlying issue and something as simple as making a false statement? And are you satisfied with the state of play right now with the lack of prosecution in this area?
Thank you, Senator Whitehouse, for asking those questions. I should start by saying 18 U.S.C. 1001 is a bread and butter statute that we use in our corruption cases and our fraud cases. It's an important statute. It's one of the best ways for us to get to the heart of people who are trying to defraud the United States or lie to an agency of the United States. So we fully embrace and understand the importance of robust enforcement of 1001 in appropriate circumstances.
But I'm correct that no 1001 cases have been brought about question 15 and the answers to it that appear to be false.
And you've highlighted, I think, some of the problems that we encounter, particularly in the last several years, regarding how to get to the bottom of some of the activities and the flow of money that goes through 501c4s and super PACs. One of your charts described a scenario in which an anonymous donor provides money to a shell company and then contributes to a super PAC. That is, in fact, something we could and would prosecute under 441F.
But haven't.
Not yet. Without discussing ongoing investigations, we can assure you that we are incredibly vigilant about the use of these organizations as an end run around contribution limits.
Well, I fully respect the constraints, particularly of Grand Jury Rule 6E, that you can't discuss ongoing investigations and you can't discuss matters that are before a grand jury. But I believe it's perfectly legitimate to say whether a category of offense is being prosecuted or not anywhere in the department, and whether or not the department has grand jury investigations addressing a category of offense underway, without going into the details of who or where. And as I understand it, there's no activity at this point within the Department of Justice, either on false statements made in response to question 15 or under 441F for the shell identity laundering into a super PAC.
Well, I actually can't comment on any ongoing grand jury matters, but setting that aside, I do want to assure you, Senator Whitehouse, that
Can I infer from that there actually is a grand jury matter that might be going on, or can you not even say that?
Well, I wouldn't want to tell you that.
Okay. So as far as I can know, there's zero activity.
And I do want to assure you, Senator Whitehouse, that our public integrity section within the criminal division and the 94 U.S. attorneys' offices are focused on these kinds of activities. 441F is a statute that our public integrity section has used repeatedly over the last several years. We used it prior to Citizens United, 441F, in the context of conduit contributions, where essentially people were using shell donors or straw donors to funnel money to candidates. Post Citizens United, no, those people don't need to use those kind of conduit schemes anymore. They simply donate directly to a super PAC because there are no limits on individual expenditures. So our use—
Unless they want to hide their identity. And then they do the shell corporation thing, and if that's the 441F case, I would think that that's something that could be brought. There's nothing that would legally inhibit bringing a 441F prosecution in a fact pattern in which a donor creates a shell corporation exclusively for the purpose of hiding their identity, and then has the shell corporation, which they control and which is for the exclusive purpose of hiding their identity, make their contribution in its name to a super PAC, correct?
I absolutely agree.
Okay.